گیسٹ اسپیکر ہیں آج کے انہیں تھوڑی سی لیٹ ہوگی بٹ آئی ایشور یو گائز کہ آپ نے جو انتظار کیا ہے اس ورک شاپ کو اٹینڈ کرنے کے بعد آپ کو جو ہے ریگریٹس نہیں ہوں گے بلکہ آپ دعائیں دے کر ہی جائیں گے. So I'm very elated to welcome you all to the third session of our first virtual workshop on art of voting that will be on the art of memorial writing. With that, I would like to invite Ms. Khansa, the co-founder of Lovits, to have the floor and to introduce and invite our today's guest speaker. Over to you, Khansa.
Assalamu alaikum everyone. I hope you all are fine. So our today's guest speaker name is Mr. Umair Ahmed, and he will be demonstrating us the tips and tricks we need to write a best memorial. So currently he is practicing lawyer in Lahore, specializing in constitutional, commercial and corporate laws. He is graduated from LUMS, Lahore, and with major in law and minor in politics. He has also participated in both national and international moot court competitions, including the prestigious Philip C. Jessup International Law Moot Court Competition in 2017. And not least at all, he has been the moot coach at LUMS Lahore. So let's welcome Mr. Umair Ahmed. Sir, we are so honored and appreciated to have you. Thank you so much for your time. And please, you have the floor now. So,
Thank you everyone. Can you hear me? Everybody can hear me? I hope everyone can hear me.
yes, sir.
Everybody can hear me? Okay, thank you for having me. Thank you for everything you said, and I'm sorry to have kept everyone waiting. I see that we have quite an audience here, and I'm really sorry to have wasted everyone's time for about 10-15 minutes. I was just facing some internet issues and I needed to fix that before joining, and I hope that there will be no further internet issues, but if at any point there's an issue with you all being able to hear me or see me, just let me know and I will try and fix it, but I hope that won't happen. Anyways, so I've been asked to talk a little bit about the art of writing a memorial. I'm not sure if it's an art so much as it is a science, because in my experience, what I've realized is that the more teams are able to stick to the basics of it, the basics of good legal writing and the rules of a competition, the more likely they are to write a successful memo. Before we get into it, before we start talking about how to write a good memo, I think it's important to understand what is a memo and what is the significance of a memo in a moot court competition generally. So, contrary to what moot court competitions are often perceived as by people who haven't participated in them, it's very less of your time is in a moot court competition is actually spent on speaking, on oral presentations, and a lot more of it is spent on preparing, researching, drafting, constructing arguments, sitting together with a team, practicing with a coach, etc., etc. So within that larger scheme, before you, I mean, this is generally true for all competition, before you even get to the venue where the competition is being carried out, or before even the dates of the competition, if it's on Zoom, you will submit written submissions. There are different names for them for different competitions, depending on what kind of court a competition is trying to simulate. Some moot court competitions will ask you to draft actual court pleadings. Some will just ask you to draft your submissions in written form, and that's how it goes. So that particular component of it, the written component of it, is what we will cover today, and it's significance, I think, is that of at least an equal value as the oral rounds. Well, to start off, whenever you do oral arguments in a round, in most moot court competitions, whatever points you score on the written component of the competition will be made part of your points for any round that you participate in. So if, for example, you get 80 out of 100 on your written submission, then every match that you participate on you will carry that 80 out of 100. And if you do well on a moot court competition, on the written part of a moot court competition, then even if you're not as good as the other team's oral arguments, but you've done a better job in the written part, there is some possibility that you might end up winning that round, in spite of you being equal to or maybe not as good as the other side's oral submissions. So it's really, really important in that way. But even if that's not the case for some moot court competitions, which may or may not be true, I'm not aware of any such competitions, but even if that is not the case, even if your written arguments points are not being considered for each round that you participate in, the effort that you make in writing a good memo, the effort that you make in researching your arguments and then putting them on paper will really help you when it comes to oral rounds. So if you've done a good job at writing your arguments well, then you will see that on the first level, it tests the logical consistency of the legal argument that you've come up with. So if you come up with an argument and if you're able to write it down properly, then that means that it is a good, logically consistent legal argument, provided that the research that you've conducted is correct. And by correct, I mean the sources are authentic. You're not relying on something that you cannot rely on. So if that is the case, then if your research is correct, then you will be able to write it well. And then once you do write it well, then you understand your argument better. And if you understand your argument better, when you present that argument before a court of law, you will see that the court will appreciate the fact that you are clear in terms of what you're trying to convince them of, and you're also able to answer their questions better. So whatever you write in your written submissions will not only affect the points that you get for each round that you participate in, it will also be a test of how good your arguments are, and B, it will reflect in your oral presentations. It's very unlikely that you have done a poor job at your written arguments and you are spectacular when it comes to oral arguments. Because if you've done well, you're clear about what you have to say, you're convinced of it yourself, and so your clarity and your confidence in your arguments then reflects in the oral rounds. And I think that makes written submissions very, very important. So with that understanding, let's discuss the correct way of approaching the writing part. So I understand that before this, there was everyone that is here would have had some exposure to a moot court competition, how it works at least. So you all know that there is a moot court problem that you get or a fact pattern that you get, and you are told that you are required to make submissions on both sides of that fact pattern. And not only will that be in the oral rounds, you will also have to make written submissions. Along with that information, you're also told that there is a certain court that you have to be before. And that is important because that will affect the research that you carry out or the arguments that you build. So for example, if you're before the International Court of Justice, you will know that there are certain kinds of arguments you can make here and certain kinds of arguments that you can't make here. And if you're before, let's say, the Supreme Court of Pakistan, then you will know that there are certain kinds of arguments which are quite different from the arguments that you would make at the ICJ that you will be making before the Supreme Court of Pakistan. So in this is the broad structure within which your written arguments come in. Now, the way to approach it is first, and this is what I recommend to everyone. You should, like the very first thing that you should do is try to figure out what the competition is requiring of you. Most competitions will have a set of rules These rules will specify what they're looking for in a written submission or a memo, memorial, whatever they want to call it. They will specify, sometimes they will specify the number of words that they're looking for, or the number of pages that they're looking for, the kind of formatting that they want it to have, what font size, what font style, what constituent parts they will expect in a memorial. So sometimes they will ask for a statement of facts, a statement of jurisdiction, index of authorities, table of contents, an index of abbreviations that you will be using. They will also say that we want the citations to be in a particular style. There are several styles. So you have to, the first thing that you have to do when approaching the writing part of a moot court competition is thoroughly understand what the competition is asking for. It's important, and sometimes I think it's overlooked, because these things do carry points. One of the things that you are being tested on in a moot court competition is your ability to follow instructions. So for example, if the moot court competition says that your memorial should not be less than 10 and more than 15 pages of text, size 11, style Times New Roman with 1-inch margins on each sides, and you submit a memo that is not consistent with these instructions, then you will lose points. And it would be very unfortunate for you to work all that effort and then submit a memo and lose points on something as simple as following instructions. That, I think, is the first thing that you need to do when approaching the writing part of a moot court competition. That is to go over the instructions or the requirements of a written submission for a moot court competition. Once you've gone over it, you will see that there are certain parts of a moot court memorial that would be mechanical, that will not require a lot of research or thought or argumentation. I would recommend you do that part straight away. You get that out of the way. You just write whatever parts of it do not require any research. So for example, they could ask you to write a statement of facts. You already have the facts with you. You just need to summarize them in compliance with whatever the instructions are. It's like 2 hours of work. Just do it, get that part out of the way. And leave for later the chunkier bit, which is the pleadings, which is the arguments that you will be presenting. And there are several ways that competitions go about that. But there are certain tips and tricks that I think if I could share with you, and if you could keep those in mind, then that could be helpful for your mooting careers. So once you've gotten rid of all the mechanical bits, the parts that will not require you to do a lot of research or thought, that is when you get to writing the pleadings. Pleadings, the way they're supposed to be written, there are several ways. There are several ways, and several people have preferences. I think that the best way to write pleadings is using the IRAC method. I assume that everyone is familiar with that. If not, then I will just quickly go over it. It is a way of writing legal arguments where you start with the issue, which is the I part of the IRAC, followed by the rule, which is the R part, application A, and conclusion C. It's something that is taught across law schools throughout the world. It is a way in which students attempt exam questions, but it is something that is, I think, applicable to any kind of legal argument that you may have to make in the written form, across formats, no matter where you are. If you're in the Supreme Court of Pakistan, you can use IRAC. If you're drafting a writ petition, you can use IRAC. Whatever you're doing, you can use IRAC. The reason I say IRAC is particularly useful is because A, it really does test whether the argument that you're making is a good one or a bad one. So the way it tests it is as follows. Whenever you're writing in the IRAC format, you will first frame an issue, which will be a question, a legal question. When you're done with the IRAC, which is when you framed the issue, when you've stated the rule, when you provided the application, and then you get to the conclusion part, a very good test is, does your conclusion clearly answer the question that you posed when you framed the issue? And if it does, then again, provided that your research is correct, if your conclusion clearly answers the question that you raised, then you're in the right direction. But if it does not, then perhaps you need to take a step back. You need to take a step back and see if the issue that you framed was too broad. The argument that you came up with has too many parts. And when you continue with that process, what you will realize is that you will be able to break your legal argument down into smaller parts in a way that is a lot more effective than you would have been able to do otherwise. So that is the broad sort of scheme of writing that you should follow, in my opinion, and I'm sure people can disagree. There are some comments. Do I need to go over them? Oh, okay. So yeah, IRAC. Issue, rule, application, conclusion. That is the way to write legal arguments. I will get into more detail about how that works, what would be a good example of an IRAC, and how the whole structure works in a little while. I'll try to share my screen and show you a small IRAC so that you can understand what it is. But for now, it's important that everybody be able to appreciate the importance of writing in this way, because it will test the consistency of a good legal argument. Okay. So that's the first bit. You write in the IRAC format. That's the overall general scheme that you will follow. But in order to do your IRAC, you need to be able to identify what is the first step of the IRAC: issues, questions, right? And for you to be able to do that, you need to first conduct research, because aapke samne facts aa jayenge, your facts are there. You know that there are certain issues, even like most moot court problems will at the end tell you that these are the issues before the court, but those are broader issues. Within them, you have to sort of divide that up into smaller, more identifiable issues. And you're only going to be able to do that when you know the law on a particular subject, when you know what the law requires you to establish, what the onus on either side is for you to be able to prove that issue either for or against. So that is the first step. When you do your legal research on a particular set of facts, you've done your research now. Now you know exactly what kind of issues you can frame out of that broader issue. And once you've done that, you start IRACing. The way IRACing works, I will get to in a short while, if that is necessary. However, I feel that a lot of people would be already familiar with it. Another thing that is particularly important in drafting a good memo is to be able to know exactly what is required of you when you're making the argument. So these are the arguments that you're presenting in the written form, and also you will be presenting before the court when the oral rounds come by. So it's important to know exactly what the onus of proof or the requirement from your side is. The reason I say that is because your arguments, your IRACs will have to follow a particular structure. So let's say that it is required for you to prove that a certain legal obligation was breached, right? In order to prove that a legal obligation was breached, you have to prove that there are certain elements of whatever that legal obligation was, A, B, and C, and either one of them was breached or all of them were breached. Now that depends on exactly what the competition problem requires of you. What do you have to establish in order to prove your side of the case? For example, if one side has to say that we had acted in compliance with our legal obligation, then they will have to prove all three elements of that obligation. And if the other side has to prove that the other side had violated that obligation, then they would have to prove that they had breached either of the three elements, or two of the three elements, or three of the three elements. So it's important to know exactly what is required of your side when you're drafting a legal memo, a moot court memorial. That's also important because when somebody reads your written submissions, because judges are going to be marking that, and oftentimes these judges are going to be marking that even before the competition starts. So they're not going to wait for you to be able to explain what you've written. They're just going to be giving you points based on what they see on that paper. It should be clear to them that you have an understanding of what the onus of proof was on you. They should be able to tell that when you were framing these issues and making these arguments, you knew that you had to accomplish all of what you set out to accomplish, or that you did not take upon yourself any onus that you did not have to establish. Okay, so that's another important part that you need to keep in mind when drafting legal memorials. That's the second thing. And in addition to all of this, the third most important thing in writing a good memo is to write in a way that is clear and concise. Lots of people will tell you that it's cliche, but let me just explain what I mean by this. So oftentimes we will see that moot court competitions are about international law, right? It's quite rare for moot court competitions to be about domestic law. One of the things that is different about international law, public international law in particular, is that the sources of law are not as clear as they are in domestic law. So what ends up happening is that you have to work through a ton of different sources to establish that there was a legal obligation, which is at the core of whatever argument that you're trying to make. In doing so, when you've done a lot of research and when you've pointed out or looked at several areas of research, you've looked at treaties, you've looked at court decisions, you've looked at scholarly opinions, books, articles, then you've got a lot of material to put down on a piece of paper for them to be for you to be able to say that this is a legal obligation that I think was breached, or this is a principle of international law that I think I want to build upon. When you start doing that, you put a lot of information in a very, very concise sort of a way, but that is often not very, very clear. So one particular way in which I think you can tackle this problem is by coming up with a rule statement, which is to say that a statement of law which is clear and understandable and could have several different authorities or sources that you rely upon to come up with it. So for example, you could say that as a by way of example only, that under international law, espionage using unarmed drones is illegal. Now, if you say that, you will generally be required to establish that with a ton of different sources of international law. instead of putting all of that material in the text of your memo, I have found that it's better to keep that text bit clear of those sources and put all of them down in your footnotes. What that does is that instead of confusing the reader with several different authorities that you relied upon to come up with this conclusion, you just tell them what your thesis law statement is, and then put all the authorities down in the footnote. So if they're interested in checking the veracity of the claim that you've made, that this is what a statement of international law is, then they can go and look at the footnotes that you provided. But they, in order to appreciate your argument, they should not be required to go over all of the sources that you relied upon. So for you to be saying in your legal memo that according to the opinion of XYZ, who is a professor of international law at ABC University, which would be a tedious exercise and will take away from the impact that your argument could make otherwise. So once you start doing that, you will see that your argument, when you present it to somebody, and you could do that, you could share it with a colleague who is not part of that moot court competition, a classmate, a professor, and ask them to read it. And if it is clear and concise, then they will be able to understand the argument that you're making. And if it is not clear and concise in this manner, then they will have questions. And I think that is a very good test of whether you need to make it clearer and more concise. So those are some of the tips that I think should be used in drafting a moot court problem, in drafting a moot court memo or written pleading, whatever you want to call it. So I think one thing that I had planned that I would do at this point is show you what a moot court, a good moot court memorial will look like, right? So for that, if I could just share my screen and show you a moot court memorial that has done well. Can everybody see my screen? Yes, no? Yes?
Yes,
Yes, sir, it's visible.
Okay. So this is one of the, so this is a memo that was submitted for the 2016 Jessup competition. And this is one of the Baxter memos, which are the two best memos for the entire competition. So you can see, this is going to be different based on what competition you participate in, but I think this is a good benchmark of what a good memorial should look like. So you can see there's a cover page that's followed by a table of contents, and one of the things that I think is important to appreciate in this table of contents is that in the pleadings part, you can see that every issue is divided into several. So these Roman numerals are the issues that are made by the competition itself, right? And the team that is submitting this memorial, this is from the respondent side, has divided that up into several sub-arguments. You can see that this is Roman numeral 1, which is followed by A, B, and within A and B, there is 1, 2, 3, and in B, there is other Roman numerals as well. I will get into what this actually looks like, but it's just important to appreciate that when writing a memorial, it's always good to divide your argument up into smaller constituent parts. What that will do is it will make it easier for whoever is reading it to be able to appreciate the argument that you're making, understand it, fathom it, because whoever that person is probably has to go through a lot of these, and that takes a lot of time. And secondly, it will make your own understanding of your arguments a lot better. So we'll get into what it looks like. Acha, followed by that is this index of authorities. This, I mean, it's just a set of all the authorities that you relied upon. You can see that in order to make a good memo, you have to be very, very thorough and rely on a ton of authorities. It's important that you be able to get your get your way around with Microsoft Word. These can be some very technical or advanced features on MS Word, and if you're not already familiar with it, I think it's important that everybody just go over a tutorial on YouTube and learn how to make indexes of authorities and tables of contents on Microsoft Office Word. Okay, let's then get on to what written pleadings should look like. So this is the pleadings part, right? And I mean, I'm sure none of you are already aware of whatever the facts of the competition are, but let's just look at it regardless of that. So this is the issue. This is the issue that was framed by the competition itself. Can everybody see it?
Yes, sir, it's visible.
It's visible. Okay, this is the issue that was framed by the competition itself. Followed by that are two arguments that the respondent side is making. The first is that the Frost files are inadmissible. That is divided further into 1, 2, and 3. And the second is that even if the court finds the documents to be admissible, they do not evidence any breach of an international obligation owed to Estonia. Let's now look at the constituent parts. Now, this is part A, which says that the forest files are inadmissible. Part A is divided into 1, 2, and 3. 1 says that irrelevant evidence is inadmissible before this court. Now, this is sort of the I part of the IRAC. Okay, and obviously in a moot court competition, when you're writing a memorial, you will not write it as a question, you will write it as a statement, as an assertion. And in that way, it sort of becomes like CRAC. You write your conclusion twice. So you will see that this is essentially the argument that they're trying to make, that irrelevant evidence is inadmissible before this court. Ab yahan pe jab aap dekhenge, this is where what I mean when I say that you have to be concise. Now they've said that only relevant evidence is admissible before this court, and the burden of evidence lies upon the party seeking to prove a claim. This is a concise statement of the law. This carries with it a footnote. The footnote says, it appears to be it appears to be a book titled General Principles of Procedural Law in the Statute of the International Court of Justice, published in 2006. And they've used this to make this statement. Now, what they could have done instead, which would have been incorrect, was that in a book titled General Principles of Procedural Law in the Statute of the International Court of Justice, a commentary cited as blah, 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 authored by this XYZ person on page AB 123, whatever, the author has stated that only relevant evidence is admissible before this court, and the burden of evidence lies upon the party seeking to prove a claim. What that would have done is, if somebody were to read it, they would have found it incredibly difficult to get out what you're trying to say, the argument that you're trying to build. So instead of doing that, they've just made a statement of law and they've backed it by a footnote. Then they made another statement of law and they've backed it by another footnote, etc., etc., etc. So in doing so, in all of these, I think you can see that there are at least 7 statements of law which they've backed by several authorities. They've tried to establish that irrelevant evidence is inadmissible before this court. Then they've made a second argument which says that documents are irrelevant if they cannot be authenticated. Again, international tribunals such as Special Tribunal of Lebanon, International Criminal Court, and the International Criminal Tribunal of Yugoslavia note that a document's prima facie reliability is essential in determining whether prerequisite of relevance is met. Then they provide case law, etc., etc. Lots of sources have been cited in order to make a point. And after that, now this is so in the first 2 parts, they've clarified exactly what the law is in a concise manner. And then here in part 3, they've applied the law on the facts of that particular case. So this is where they say that the Frost files do not derive from personal and direct confidence from the purported author, etc., etc., etc. So the point is that they've in part 1 and part 2, they've concisely built 2 legal arguments, and then in part 3, they've applied those legal arguments in order to reach the conclusion that the Frost files are inadmissible. Okay, so the reason I show you this is to show to you that IRAC is a clear way of writing. It's good because most people expect it, most people have been trained in it, and most people who will be marking your moot court competition memorials are going to be familiar with this way of writing. So if you write in this way, it will help you. And you will see this, that if you read this part, and you can just Google this Baxter Award winner respondent memo on the website of, just Google Jessup Baxter Award memo 2016, and you will find this. And when you read through it, you will find that every time that they've concluded an argument, they've been able to conclusively make this statement. So a good IRAC will answer the question that it frames. It's slightly different from a question here. They've written it as a statement instead of a question, and that is the correct way to do it. You do not pose questions in a moot court memorial. You instead write it as a statement and an argument or a claim. So this is a claim, and they've completely backed it up with evidence of law here in 1 and 2, and in 3 they've applied that law to the facts of that particular competition, and they've reached the conclusion that they set out to reach in part A. This is the way that IRAC is supposed to work in the context of a moot court competition written pleading section. And obviously, once you've done this, you will be able to understand and appreciate your arguments in a way that will stand the test of presenting them before a panel of judges. And that's ultimately what is also, in a lot of ways, the purpose of requiring you to write written submissions in a moot court competition. So yes, just to summarize, the first thing is that you need to be able to understand and appreciate what exactly a moot court competition is requiring from you, what kind of formatting requirements they have, what kind of citation requirements they have, what kind of constituent parts they expect. I always recommend that you should get the mechanical parts of it out of the way first, so that you're not working on them towards the end when the deadline is approaching and you're already scramming for research and just putting things together. And then ultimately you also have to write other things like a statement of facts or a statement of jurisdiction. Just get that out of the way. The next thing is, once you've gotten all of those mechanical parts out, you need to first do your legal research. Why do you need to do your legal research? Because unless you've done your legal research, you will not be able to identify issues or arguments correctly. Once you have identified arguments correctly, start to draft your pleadings in the IRAC format, which is make a claim, make an issue, and sort of state it in the claim form. So the I part, for the purposes of a memo, will not be in the form of a question, it will be in the form of a statement, depending on what side you're on. Then you write all the law on that subject. When you're writing the law, you should always try to be concise. Do not flood that part with tons of different sources and authorities. Put all of that down in the footnotes. Just write clear statements of laws that somebody reading your memo can understand and appreciate easily. After that, apply that law to the facts of your case, and then just tie it back up to the argument that you were trying to make. It's the simplest way of writing. It is the easiest and most widely understood way of writing written arguments around the world in law schools and courtrooms, and you can use that for moot court competitions as well. And once you're done with all of this, you will ultimately have a good product that will look like what I just showed you. I think that is pretty much everything that I would have liked to cover, but I would like to open up the floor for questions and just answer questions if you have any.
Thank you so much, sir. I think that was very insightful session, and the IREC part of this session will help most of the students. Well, the floor is now open for the questions. Anybody who is engaged with us in the meeting, they can comment down their questions or raise their hands. And those people who are watching us on YouTube, they can also comment down their question. Dua Rafiq has asked a question that can we follow the method of putting the various sources in footnote in domestic law memorial as well?
Sure, yes. I think so. I think it's always good to write clearly, and one of the requirements of writing clearly is if it makes what you've written more clear, to put the sources in the footnotes, then you should do it. And I think it's something that will make your end product better. I at least do it, and I think it's very effective. So yeah, do it. But just make sure you cite properly. So you cite consistently and properly in the style that you've chosen or has been prescribed by the competition that you're participating in, and make sure that you follow that like completely. Do not miss out on commas and full stops. I think that's a particularly tricky part where people can lose points. So just make sure you comply with that style properly. Yeah.
सर हियर यहाँ पर मैं जो है अपना एक क्वेश्चन ऐड करना चाहूँगा. अगर हमें जो है रूल्स ऑफ द कंपटीशन के अंदर जो फुटनोट स्टाइल है उसका नहीं बताया गया कि कौन सा फॉर्मेट आपने यूज करना है, तो आइडियल फॉर्मेट कौन सा होना चाहिए जो कि आप रेकमेंड करना चाहेंगे?
I always think Oscola is the best because it's the easiest. I think everybody should just pick the easiest way of citation, because like the less it requires, the less likelihood there is that you will make mistakes. So just stick to Oscola, and I don't think I'd like to recommend any particular style, just whatever works for you. But be consistent with it. You should never use one style in one part of your memo and then a different style in another part of your memo. Happens quite frequently when many people are working on writing a memo and one person uses one style and another person uses another style. So just make sure it's consistent throughout. Whatever style works for you, use it. I think Oscola is the easiest, so just stick to that.
Yes.
Thank you so much, sir. We are having questions from Manur. How do we make issues out of issues in a mood problem?
This is an intuitive process, and I think this goes more towards legal research than writing. But when you will see that you have to see if the competition problem itself has framed any issues. Sometimes that will happen. If that is already done, then you will see that within those issues, there will be several requirements from each side. So the applicant will be required to prove several things, A, B, C, and the respondent will be required to prove the corresponding sort of inverse of those things, A, B, C, or just whatever is the opposite of that. Within that, you will find when you do your legal research, you will find that certain obligations, certain breaches, certain rights, they have certain elements. And sometimes you have to prove all of them. Sometimes you have to prove one or two of them. Sometimes you have to prove one out of 3 or 4 of them. It's disjunctive, it's conjunctive. So when you do your legal research, you will see that you cannot address this argument as one part. You will have to break it down into several smaller parts. A very good test of whether you've broken it down into the correct number of smaller parts is to see if you're able to do the IRAC properly. So if you're able to do the IRAC in a way where you're answering the question that you framed in a clear way, then you cannot break it down any further. But if you answer the question with certain qualifiers or caveats or something of that sort, then perhaps you need to break it down into smaller parts. So just when you do your research, it will happen quite intuitively. If it doesn't happen, try to break it down using whatever elements you think, or whatever legal tests you're able to find out of your research. I hope that explains or answers your question, but if it doesn't, you can ask again.
Thank
Any
you
other
so much,
questions?
sir. We are having questions from Uruj Lashari that how can we make our argument strong when we don't have case law for that? And it happens really कि हम research के दौरान जो है case laws वाकई कभी कभी होते भी नहीं है जब issues हमारे पास नहीं आ जाते हैं तो उस केस के अंदर जो है जजेस को किस तरीके से मतलब मुत्तफिक किया जाए लाइक कौन सी दूसरी सेकेंडरी अथॉरिटीज हैं या फिर किस तरीके से हम उस सिचुएशन को टैकल कर सकते हैं इन अवर राइटिंग पार्ट.
That depends on what court you're before. So if you're before the International Court of Justice, case law is important, but it's really not important in the same way that case law is important in domestic courts or in common law courts like Pakistan. But let's say you're in a situation where you can't find case law that supports the argument that you're trying to build, then use innovative analogies from case law that might not be similar to what you're arguing. Sometimes there are issues before you that have never been addressed. You can use analogies to say that in another case with different facts, a certain principle was followed. And if you apply that same principle to these facts, then you will come to this conclusion. So you can analogize. The other thing that you can do is you can conduct comparative research. So for example, if you can't find anything in the jurisprudence of one country, you can find precedents in the jurisprudence of another country where similar cases were brought before courts and they had similar facts to your facts and they answered them in a certain way. They might not carry the same value as case law from the same jurisdiction, but it will carry a lot of persuasive value. In fact, in a moot court competitions context, I think it would get you a lot more marks because it will show that you've been more thorough with your research than other teams. So yeah, you analogize and we use comparative jurisdictions to find case law. And the other thing that you could do is you could use other sources. You could use other sources of law. You could use scholarly works. You could use books, articles, etc. in order to, you know, and if it is something jiske upar case law exists nahi karta, so judges will also be able to appreciate that. They will know that this is something that has not been conclusively answered by courts. So you are using alternative sources to back up your argument, which will depend on what court you are in. So if you're in the ICJ, then scholarly opinion does carry a lot of weight, and you can use that. Even in domestic courts, there are certain books that carry a lot of weight, and you can rely on those. So yeah, there are alternatives to case law.
Thank you so much, sir. Now we will take up the question of Nematullah. Nematullah, please unmute yourself and ask your query.
Assalamu alaikum. This is me, Nematullah, and I'm a student of Federal Urdu University from Karachi. Sir, my question is that, before the question, I want to ask something. Sir, participation in the Philip C. Joseph International Law Moot Court competition involves both writing a memorial and oral advocacy. Many teams lost points and failed in advance when their memorial did not comply with the writing requirements of the competition. Lacked professionalism and more important, did not provide legal clarity and reasoning in developing their legal arguments. I think every participant should realize that in the real legal practice, well-reasoned, polished, professional communications, both in writing and advocacy, are must. Sir, how do we write a memorial arguments? What is the format standard moot court memorial? How does art bring awareness? Sir, this is it.
Could you repeat the last part?
Sir, how does art bring awareness?
So I think the best way to answer that question is that just follow the guidelines. Just follow the guidelines that they give you. So if they have, particularly for the Jessup, as I just showed you on my screen, every year they have this best memorial award, and they publish that on their website. So you can just look at that. That's a very good specimen for what a good memo looks like for the Jessup. For other competitions, obviously you're going to have to look at what they require from a memo. But ultimately, the important thing is just follow the guidelines that they give you, be thorough in your research, and just write it down in the IRAC format. Just make sure that you follow all of these steps. Another thing that I've often found teams suffer with is that they don't work throughout the period of time that they're given to work on the memo. They often just delay that, procrastinate till the very end, and then they have a week left to write like 9,000 words of, 9,000 words worth of memorial, which is very, very difficult, almost impossible. So just keep working consistently throughout that period of time, follow the guidelines that are given to you by the competition, be thorough in your research, and I think ultimately you will come up with a good memo. Yeah, that's I think what you can do. Are there other questions?
Thank you so much, sir. Thank you for your such a great time.
No problem.
Jamsher, you can go with your question. Please unmute yourself.
First of all, thankful to Sir Umair Ahmed and Legal Rights Forum for organizing an amazing session. So, well, my query is, in a memorial, will it be good to include only part of judgment which is necessary for our issue, instead of including the entire judgment of a case or an observation made by a judge?
Thank you. I don't think you should ever include the entire judgment. Always, well, personally, I think you should never include quotations from anything. Just never, ever. This is what I personally believe, that you should not have to ever quote entire sentences or paragraphs from a judgment or any source whatsoever in any legal writing, be it a memo for a moot court competition or any other sort of legal writing. I know that in Pakistan we do that a lot. Our judgments quote entire blocks of text from other judgments, but I think it would be easier if the judge if you could just write or paraphrase whatever you're trying to extract out of that judgment and then cite it. When you're citing it, make sure that you pin cite it, which is to say that you provide the exact point in that text where whatever you're citing can be located. It can be a paragraph number, a page number of a law report, whatever can help us reach that point in that text at which you are referring. So for example, if you want to refer to paragraph 36 of a judgment, then your citation should provide or state at the end that it's paragraph 36 of that judgment that you are relying upon. So no, I don't think you should ever rely on entire judgments. I also don't think you should ever reproduce paragraphs out of a judgment. I think you should just refer to a paragraph, refer to whatever you're trying to rely on and pin cite it in the footnote. Just tell that this is the exact paragraph number that you're relying upon. And I think that is enough, and it makes the reader's job a lot easier. Any other questions?
Thank you, sir. Abdul Nabi, you can unmute yourself and ask your query.
Sir, how we can draft the section in the memo, and what's the method of drafting the memorial?
What's the first part? Could you repeat?
Sir, how we can draft the memo section in memo, and how we draft the memorial?
Section memo, I'm not sure what you mean by that.
In sections and in memo means how we can draft that section called means in memo, how we can write it in the memo.
I'm not aware of what you mean by a section in
Sir,
a memo.
I think a network should by.
Huh? Hello?
Hello, sir.
Yes.
सर सेक्शन वो कैसे इसमें ड्राफ्ट किया जाएगा, वो किस तरह से लिखा जाएगा मेमो में?
सेक्शन मतलब किसी कानून का सेक्शन?
जी सर, कानून का सेक्शन यार कुछ ऐसे होते हैं, कॉन्ट्रैक्ट में होते हैं, सीपीसी में होते हैं, सिविल में।
हाँ बिल्कुल। सेक्शन
और सर उसका मेथड क्या होना चाहिए बता दीजिए।
I just think you shouldn't quote it. You shouldn't quote the text of a section. I mean, you shouldn't unless it's really important to appreciate the exact language that is used in a section, which can happen. There are instances where you need to tell the court that this word was used in a particular section instead of some other word that could have been used, which is why you should read it in a certain way. If that is what the argument you're trying to make is, then just reproduce that. Like in quotation marks, you can say that section XYZ of the ABC Act is reproduced for the convenience of the court, and you can just reproduce that then. If it's a particularly long section and you're worried that it will take out a lot of words from the word limit that you've been given, then you can also reproduce parts of a section. And as long as you cite the section, the reader can just open the book and find the section and find that particular part. So you could either reproduce the entire section, but I would only do that when it's absolutely necessary, or you could reproduce certain parts or a certain word even out of a section and make the argument that this word was used in a section instead of another word, and that is why you should read it in a certain way. So yeah, that's how you should go about that. Other questions?
Thank you so much, sir. I think we have taken so much time of yours. I will just take last question of Javeria. Javeria, if you can please unmute yourself.
Okay, so Assalamu alaikum, sir. My basic question is that when we see drafting of a memorial, we see that there are 2 or 3 people coming together and making that document. So how do you suggest we ensure there's a cohesion in the language and the terms and the way that document is written?
That is a very important question, and I think in the three and a half years that I've coached moot court teams, it's one of the most important contributions that I think any one person in a team or any coach can make to a team is to get them to do it together. So I always tell whatever team I'm working with to work together. Teams have this inclination to divide things up and assign responsibilities to members of a team and get them to do their work and then reconvene and then look at each other's work. I think that is sometimes more efficient, but it is not in consistency with the spirit of a moot court competition. I think one of the best things that you get out of participating in a moot court competition is the sense of working together with people and not in isolation with each other. So, I mean, we were living in a very difficult time in terms of being able to meet people. Lots of law schools are closed and you can't really meet the team members very easily. But whenever it is possible, I always recommend my teams to sit together and draft things, to at least be in the same room when you're drafting things so you can share information with your colleagues. You can ask somebody who is working on something else, hey, listen, I'm writing this. Do you think I should write it in this way or that way? Do you think this particular word should go here or not? What that will do is it will make sure that everybody is aware of everything that the team is doing. Everybody being and this will also be helpful when you end up in the oral rounds, because if certain people are very strong at some parts of your submissions and not very strong at other parts, then they will have to really go back and learn everything from the beginning. But if everybody has worked together, then everybody is equally good in terms of how well they understand the arguments that the entire team is making. So I think the best way to make sure that there is consistency is to sit down and draft together in the same room to the extent possible, and then also once you're done with the drafting part, just share it with each other, make sure everybody goes over it, gives feedback. We have Google Docs now. That's really helpful. Everybody can just leave comments and just make sure that the whole thing is consistent. But the most important response to your question is do it together in one room. That's the best way to do it, in my opinion. Any other questions?
Thank you very much, sir, for answering so many queries. Khansa, I think we should proceed towards closing the session now. If you can please have the floor.
Yes. Thank you so much, sir, for having your presence here. We are so appreciated and honored to hear from you. It was really an insightful session for sure. And thank you so much to all the participants who are being participating in our 3 sessions so far. And tomorrow we will be having our last session, inshallah. So do join it, and goodbye till that. Allah Hafiz.